perfect example of judges doing what judges do all the time. Our case went to trial. We had our evidentiary hearing in mid-April of this year. And the trial lasted 3.5 days. Judge Kennedy heard us for 3.5 days, and during that 3.5 day period, I think that there were virtually no objections that were filed either by the petitioner, by our side, or by the respondents, by the government, with respect to the process itself, with respect to the standards of detention that Judge Kennedy adopted from other opinions that had been filed in the court, from Judge Kennedy's adoption of a burden of proof that has been consistently applied in these cases.
Which was?
Which was that the government bears the burden of proof by a preponderance of the evidence. And uniformly, the judges have indicated that that's an appropriate burden, and indeed, the DC Circuit has affirmed the trial judges in fashioning that burden of proof and indicating that that meets constitutional muster in their view. Even the admission of hearsay evidence itself was not a matter by the time we went to trial with Judge Kennedy that raised any objections. And I would say that as I think back on the trial, every single piece of evidence that was offered by either side was accepted by Judge Kennedy. He received it. And I think his 44-page opinion, which goes through in minute detail all of the claims and all of the evidence that was put before him, indicates to me that he gave due consideration to each item of evidence that was submitted to him. And not once during the course of this trial did Judge Kennedy ever complain or suggest that he needed additional guidance or he needed legislative assistance in order to conduct this trial, in order to make the decision that he ultimately made. I think he did in this case exactly what he's done in every other case that I've been in front of him over the years of practice that I've had an opportunity to practice before him. And what he did was he methodically and carefully weighed and sifted the evidence. And from that, he ascertained what the facts were. And then he thoughtfully applied the law to those facts and made a decision. In our case, Judge Kennedy found that Mr. Mingazov, our client, was not lawfully detained, and he granted the petition for writ of habeas corpus. In a previous case, with different facts, Judge Kennedy sifted the evidence and made a different decision, and in that case, he denied the writ. And I think as Judge Sessions has pointed out with respect to the record, it appears to me that judges of the United States District Court here are doing exactly what Judge Kennedy did. That is, they're sifting evidence, they're ascertaining facts, they're applying the law, and they're making decisions in individual cases, just as judges do all the time. I'll conclude my remarks here at the beginning with just some personal observations. And the first one that I would make is that this is not just merely an academic exercise. There are flesh and blood human beings, flesh and blood men like Ravil Mingazov, who have been locked up in Guantanamo, in his case we now know unjustly, for 8.5 years. I guess I would ask the question, how much longer should we ask them to wait while Congress, perhaps, and the courts go through another round of corrective, if I can put that in quotes, legislation and judicial challenge to that legislation? My second point is that unless habeas includes an effective remedy, and the remedy for habeas is release. So unless release is an effective remedy that the judges can grant in habeas cases, I do think that the habeas cases may well become academic exercises. And my own view is that ultimately that will do more harm than good to the courts and to the litigants and, frankly, in my view, to the national security interests of our country. So finally, I would say that, in my view, I may not agree with all of the decisions. I think you could quibble individually from time to time, but by and large, the courts are doing just fine. They're doing what courts are supposed to do. I don't believe that they are legislating. I think what they're doing is they're taking a body of law, principally the authorization for the use of military force, as informed by another body of law, the laws of war, and from that body of law, they're developing coherent standards, they're applying procedures that have become well accepted in the courts. Those procedures have been confirmed now by the DC Circuit in at least two cases, the Al-Bahani case and the Awad case that was decided earlier this week. And it's hard for me to see how Congress, especially the Congress that we have in its partisan climate that exists today, could do a better job than what the courts are doing. And I think, okay, this is the same Congress that today is calling for investigations of government and civilian lawyers who represent the detainees. And this is the same Congress that would tie the president's hands in terms of that ultimate remedy of release, even to third countries for men like Ravil Mingazov, who have been through a complete and thorough habeas corpus proceeding with an independent Article III judge and who have been found to be unlawfully detained. And I would say that Congress has done its job. Congress has done its legislative job. It adopted the authorization for the use of military force, and it gave the framework for deciding these habeas cases. The courts should now be allowed to do their job of finding facts and applying the law to those facts. And our system of government that relies on concepts such as separation of powers and checks and balances needs to allow the separate branches to do their own responsibilities in their areas. The Constitution envisions that judges will apply the law to individual cases, and Congress should not be interfering with these ongoing individual cases that are now before the courts. Neither Congress nor the executive, we often think of habeas corpus as the check on executive detention, but it also applies to Congress. And neither Congress nor the executive can be insulated from the reach of that great writ of habeas corpus to prevent unlawful detention of unpopular individuals. So the bottom line is that I applaud Judge Sessions and his fellow judges. I applaud Human Rights First and the Constitution Project for the report that is being issued today.
Thank you very much for the presentation. I'll kickstart with one question. You mentioned that the Congress has done its job and the courts should be allowed to do their job. So where do you draw that line of demarcation?
Well, I think it's appropriate for Congress to legislate, and I think there are potentially judgment calls to be made with respect to where you draw that line of demarcation. One of the points that I would make is that now in Guantanamo there are about 180 individuals. There are cases that are pending